Welcome to Environmental Law course, dear learner and viewer. We are going to discuss the common law remedies for environment protection under the law of public nuisance in colonial India. This is something very interesting that the whole lecture is primarily gauged from the writings of the Michael Anderson, who wrote extensively on the law of public nuisance for the private purposes and the police environment in colonial India, and a study which has been carried out by Michael Anderson under the caption of the law public nuisance for private purposes and police environment in colonial India till 1947. The Michael Anderson has made very pithy observation about the common law remedies for environment protection under the public nuisance in colonial India. We'll be discussing his basic postulate and assertion in his paper, which has been widely acclaimed after the pronouncement of the Indian Supreme Court verdict on Municipal Council on Ratlam versus the Vardichan, which have given a new shape to the law of public nuisance. We'll be discussing the common law remedies for environment protection under the law of public nuisance in independent India, but we thought that before we discuss the law which has been ordained in the Indian Penal Code 1860 and the Criminal Procedure Code section 133 CRPC, it appears very appropriate to see that what is the common law remedies for environment protection under the colonial India. In this respect, what has been discussed under the paper of Michael Anderson that we will be discussing on some very finer point and observation. Here we have made a catena of the laws which were applicable in the British India and the colonial India, which have tried to see the law of public nuisance from the perspective of the law of tort and the law of crime. Besides that, it has a very salubrious provisions of law of private nuisance and law of public nuisance under the law of tort, and it has also the provision in 1860 IPC. Then still, despite the sufficiency of this law, the colonial India have been very careful and alert in matters of making law in relation to public nuisance in colonial India, and that is going to be studied under this lecture. The purpose of this lecture is to undertake a very extensive and explorative studies of the legal history of the law of public nuisance, and the legal history of the law of public nuisance talks about a very state-specific nuisance law which we have witnessed in the colonial India, and it begins from Bengal, it begins in Bombay, it begins in Gujarat, and all these three laws represent different sets and priorities to contain the public nuisance, be that nuisance relating to smoke, be that nuisance relating to the shore, be that nuisance relating to any kind of the air pollution and the water pollution. We can see the range and the classification of the nuisance law in a state-specific context of law of public nuisance, which have an overlapping and supplemental legal framework for pollution control at the state level in the British or the colonial India. We will also be discussing not only about the law per se, which has been ordained under the law of tort, which we have already discussed in lectures which we had followed earlier, but here we will be discussing how the law of public nuisance has been conceptualized by the Britishers, and it tries to see its various aspects of the law of public nuisance across the geographical spread. One is the eastern India, Bengal, another happens to be the western India, Bhopal, or you can say the central Gujarat, or we can say the Bombay, which can be said to be of the central India, now the southern India. Then we see that what is the length and breadth of the law of public nuisance dealing on the smoke, dealing on the chimneys, dealing on the air pollution, dealing with the mining pollution in Raniganj, or we will be discussing how the shore nuisance in Bombay and Colaba and the high water marks have affected the entire law of public nuisance and shaped by the British and colonial India. In this respect, my dear learner and viewer will be discussing the Bengal Smoke Nuisance Act 1905, which deals and outlines the first targeted air pollution law and how that air pollution law has been the ambient air quality in Kolkata Presidency town has been addressed under this law in 905, and what are the basic circumstances that how it tries to see the extension areas, how it defines the smoke, how it defines the honor, how it defines the entire bureaucracy to prevent the smoke nuisance, what are the power which has been conferred on the commissionerate and the inspectorate, and how it regulated the entire regulatory provisions and the penal mechanism to contain the smoke nuisance and emission from the furnaces, from the chimneys, and from the coal mining in Raniganj in West Bengal. We'll be looking at the shore nuisance of Bombay and Colaba Act of 1853, and in the coastal area, in the harbors and the seashore, how that shore nuisance has affected the most of the shipment because it has created some port and harbor activity and export and import and drain of wealth, because the most of the British's policy in the colonial India happens to be not only the colonialism but capitalism and imperialism, how the goals of colonialism, capitalism and imperialism are being set at a pace by having a large flurry of activities on the seashore, and that's why the first law on the point happens to be the shore nuisance. It is a new concept which has been innovated by the Britishers under the very conceptual framework and ambit and scope of law of public nuisance is the shore nuisance, and the law dealing with Bombay and Colaba Act of 1853. Then we have already just discussed about the basic precepts and the basic outline of the Bengal Smoke Act of 1905, which was passed in a backdrop of the industrialization in Kolkata, the chimneys, the furnaces, and as well as the discovery of the coal mines in the British India at Raniganj, closer to the Kolkata. And then we will also try to see the replica of the same law in the Bombay smoke nuisance, because all the presidency town, be that the Madras, be that the Bengal, be that the Bombay, all presidency town have witnessed a great activities of industrialization under the colonial policies of capitalism and imperialism. And then besides that, we find a common thread between the Bengal Smoke Nuisance Act 905, Bombay Smoke Nuisance Act of 1912, and Gujarat Smoke Nuisance Act of 1963. And then we will try to see that how this shore nuisance and the smoke nuisance law, which has been declared here, have been a guiding law not only for India but also it has transcended the Indian boundary, and the same law has been replicated in Bangladesh. Therefore, what we see that there is a kind of a search to see that the law of public nuisance for private purposes has been applied in the colonial India, and it tries to see that these enactments are the classical pointer and the piece of the colonial administration, the colonial environmental legislation and governance in this country. We'll be looking all these four laws before we try to see that what is the common law remedies for environment protection in independent India under the IPC and the law of tort and the judicial pronouncement of the Supreme Court and High Court. By perusing a category of cases, it was thought appropriate to look at these laws, because these laws are of colonial vintage but speaks volumes about its repercussion in shaping and guiding the law of public nuisance in matters of environmental pollution and environment protection. With this, we'll be trying to see that how the shore nuisance Bombay and Colaba Act 1953, which was passed to remove nuisance and encroachment below high water mark in the islands of Bombay and Colaba. And this is a very unique that even in the modern India, we are not going to witness any kind of a nuisance which is arising from the high water mark, and there are very rare and sporadic cases which have been brought before the court of law relating to any kind of a complaint in even the independent India that the shore nuisance happens to be a major source of the public nuisance law. And but we can see that how the Britishers envisioned, and Britishers has a sense of realization of all kind and sorts of pollution, and this shore nuisance is really something very interesting and very historical in the sense and very innovative in the sense that they realized to contain the high water mark in the islands of Bombay and Colaba. The key provisions of this act, speaking from section 1, has empowered the collector of land revenue to issue notices for removal of nuisance or encroachment in the harbor area. So this harbor area and the high water mark, it has a relevance, and then all kinds of nuisance which are being promoted and accrued in the name of the shore nuisance are to be controlled by the collector of the land revenue under the provision of section 1. It also tried to see that any affected person can appeal to the Supreme Court of Judicature at Bombay, bearing the burden of proof that how these shore nuisance are going to affect them, and to seek any kind of a legal remedy. The first and foremost thing is that burden of proof of it lies on the complainant and the appellant to establish that how high water mark in the harbor area has resulted into a kind of a shore nuisance affecting the sanity and the peaceful enjoyment of the life. Then the Shore Nuisance Bombay and Colaba Act 1853 has certain procedural and enforcement provision. It says that if no appeal is filed within 1 month, then collector could remove the nuisance under the warrant. This is very important that if the wrongdoer, or if the creator, or if the proponent of the industries or the shipyards, if they have through their furnaces and the chimney and the shore activities at the harbor have failed to bring any kind or failed to adduce any kind of the alibi and the defense, then the collector is under a duty to remove the nuisance under a warrant. So meaning thereby the word warrant implies that it is going to be more of a criminal nature, and then it can be immediately removed. As we see in the independent India, the district magistrate and subdivisional magistrate or any other magistrate is empowered to remove the public nuisance. So was the case of the Shore Nuisance Bombay and Colaba Act 1853, that the collector can remove the nuisance under the warrant. The collector has also been empowered to sell encroachment material. It is based on the same theory of the search and seizure. So the collector is also empowered to issue warrant. Collector is also empowered to sell encroachment material, to recover removal of expenses. So the removal of the nuisance, the expenses are to be realized from the sale of the encroached material with surplus fund directed by the central government. Thus, we see that the power was something very exorbitant, which has been conferred to the collector. But what is pleasant to note, that the removal of the nuisance was something, a kind of a provision which can be immediately be removed, and whatever expenses has been accrued for the removal of the public nuisance or the shore nuisance can be realized from the proceeds of the encroachment material and a surplus fund which has been created by the central government. Then the other saving clause of the Shore Nuisance Bombay and Colaba Act 1853 talks about that the government has a right over the harbor and did not preclude the civil or criminal proceeding for abating nuisance. It means the government has a preserved right over that. It means the government, there is a protection of action taken into good faith by the government, but for others there is a civil and criminal liability for abating any kind of a nuisance, and the shore nuisance and the Bombay and Colaba Act of 1853. Then we see that the Bengal Smoke Nuisance Act 905, it has a historical background, as I have already explained in the beginning while prefacing this law, that the point happens to be that the Bengal Smoke Nuisance 1905 was passed in 1905, first to control, this is the first law to control air pollution in India. So this law is one of the most rudimentary law which has been passed to control the air pollution, and how the air pollution has been created and what are the sources of the air pollution. Then this act itself mentioned that the smoke pollution which are coming from, number one is the chimney, another is the furnaces, another is the fireplaces in industrial areas like Calcutta, Howrah and Raniganj coalfield. So the one aspect is here, one aspect is here, and one aspect is here. Here we can just mention the distance between the Raniganj to Kolkata happens to be not, I can say with a precision, 175 to 200 kilometers. But even that fact, notwithstanding that fact that the Raniganj coalfield operated more than 175 kilometers away from the Kolkata, they were so alert and sensitive that the mining of the Raniganj should and the ambient air quality or the acid raining out of the coal activities and coal mining activities in Raniganj cannot hover around the skies of Calcutta, the presidency town, and that's why the British enacted the Bengal Smoke Nuisance Act. So one was the chimneys and furnaces in Kolkata and Howrah across the rivers, but these were the Calcutta and Howrah happens to be the twin cities. But when we talk of the Raniganj coalfield, it has been a far-flung area, but they realize so beyond time that maybe that the ambient air quality of Kolkata might not be worth breathing. Therefore, the Britisher brought this law. So, objective of this law, historically speaking, is the legal control over all kinds of air nuisances arising from the smoke emission, and to safeguard public health and the environment. This is very important, that the one focus was not only the environment, but the public health was very important, and in the name of public health and environment, it has gone far beyond from the industrial activities of Calcutta and Howrah to Raniganj coalfield. Then this law, the Bengal Smoke Nuisance Act 1905, has the jurisdiction relating to Calcutta and Howrah, and it represented an early legislative attempt to control industrial air pollution in all urban centers in and around the satellite locations and geographical establishment of Calcutta Presidency Town. Then the salient features of the Bengal Smoke Nuisance Act 1905, as evident from Section 1, applies to other areas of Bengal besides Calcutta and Howrah, and it extends to throughout West Bengal. It has created a Smoke Nuisance Commission, that is very important, comprising of a president and nominated member, and it also talks about that they are treated as a public servant under Section 21 of IPC. Then Section 6 and 7 prohibits and demolish the cleaning and furnaces in the specified area if they are violative of the safeguard which has been declared, and Section 8 and Section 8A talks about the penalties and excess of a smoke which has been spewed from the furnaces in the chimney without permission. Section 9 and Section 9A happens to deal with the grant of inspection right, and the inspectors were given a kind of a wide and sweeping power to have some kind of a delegation of authority by district magistrate and other officer to have a periodic inspection, and they are empowered for rule making cognizance of offenses, and to fix liability of the companies. And thus we see that right from the perusal of section 1, which talks about the extent of the application, and section 1 and 2 talks about the extent of the applications of this law, and then section 3 talks about what is furnace, what is fireplace, and what is smoke, and then it talks about the administrative paraphernalia in terms of a smoke nuisance commission and appointment of inspectors and giving wide and sweeping power which are of a criminal nature, and it is nothing short of the power of a police officer in matters of bringing the violator to the book. With these salient features of the Bengal Nuisance Act 1905, we see that the definition of the furnace have been very exhaustive. It talks about the exempted furnaces, it talks about the furnaces which comes under the law, and all kinds and all details are mentioned, whether it is steam, oil, gas, combustible fuel, reaction tower, digesters, destination plant, cover all mechanical, electrical, and chemical processes which are engaged in emission of the smoke from the fumes, vapors, soot, or gases. So it encompasses a broad range of industrial activities, and then it tries to see that the smoke which are coming out of the grit, the dust, and the fume and the obnoxious gases, that can be contained by this law. This law also tried to talk about who is the owner and what is the administrative framework, and that administrative framework vested with the Nuisance Commission, which was created by giving a chief power to the chief inspector, and the smoke nuisance inspector and other government officials were also conferred some power to look at the effective implementation of this law. The Bengal Smoke Nuisance Act 1905 have a very careful commissionerate and inspectorate to look at the cases of the smoke nuisance in Bengal, in the entire Bengal, including Howrah and Kolkata and Raniganj coalfield. Then the power of commissioner and the inspectorate, we can see that it was not less than of a power of the district magistrate or additional deputy commissioner or subdivisional magistrate acting in the jurisdiction, and this power relates to search and seizure, test and analysis of the appliances, direction to suitable action, and reporting the commission for how such finances can be improved, the functioning of these finances can be improved. With this, we see that the prohibition and the regulation in the Bengal Smoke Nuisance Act 1905 is very important in giving shape to contain the penalties and the violation. And you can realize the fact that in 1905, a fine of 2,000 or both was something very exorbitant. And then the subsequent fines was also a kind of a continuing offenses which were imposed under this law, was having a very deterrent effect of, in fact, because the value of the rupees of at that time in 1905 regarding 2,500 was a very astronomical figure, and that talks about how the government and the Britishers were very serious in containing the smoke nuisance in Bengal. Then with this we see that the Bengal Nuisance Act serves as a guiding law to see that how the apart from the Shore Nuisance Law of Bombay and Colaba Act of 1853, we have a law relating to Bengal Smoke Nuisance Act, Bombay Nuisance Act, and the Gujarat Nuisance Act. So this shore nuisance, Bombay and Colaba, which talks about the nuisance which is rising from the high water mark and the harbor areas, and whereas the Bengal Smoke Nuisance Act talks about in detail a variety of industrial applications and purposes which are operating on steam, oil, gases, and combustible fuel and reactors and digester, electrical and mechanical processes which are in habit of emitting smokes. And what is the final point, that this law has been very elaborate in creating commissionerate and inspectorate, and as well as looking at this law regarding the violation which is condemned under section 6. So it has a continuing offense. The first time offender and the second time offender has also been marked in a very clear words and clear terms. In this way, what we see that it has a very salutary impact in containing the smoke nuisance in Bengal. We can also see that this law, which has been amended in 1978 with minor amendment, has approved the same application of the law. And we also see that the modification which has been done in 1978, that talks about illegal construction and modification, that has to be taken permission from the chief inspector, and that is also valid for 1 year. It means there was a sense of a periodic review of all the sources of the smoke nuisance, and the penalty was also 2000, or it can have the imprisonment of 1 year, and it can also come very heavily, and coming heavily means that it can demolish the entire furnaces and the chimneys if at the owner's cost, if they have been habitually offending the law. And then all kind of the breach of rules also attract an imprisonment of 3 years and the fine of 5,000 years. So what comes out of the penological and sanctioning regime of the Bengal Nuisance Act 1905 is the fact that they have a very exorbitant kind of the fine, giving this impression of having a very deterrent effect and having a very salutary impact in creating a kind of an atmosphere where the smoke nuisance should not visit in the urban areas and the presidency town. So much so, it has also incorporated that whatever exercise of search and seizure and demolition will take place, it will be at the cost of the wrongdoer, and the entire overdue fees are to be realized with 12% interest and recoverable at the arrears of land revenue. It means it has criminal sanction, it has pecuniary sanctions, and it has a kind of a graded kind of a punishment. So we see this law, though it has this law, as Michael Anderson has rightly pointed out, that this law has been made for public nuisance law for private purposes, and the working of the law public nuisance in colonial India is a very interesting study to be seen through the lens of the Bengal Smoke Nuisance Act. And what it can be said in a last, as a concluding point, that this law has been a kind of a parent law to deal, parent law which have triggered the Bombay Nuisance Act and Gujarat Nuisance Act, and so much so the success story and the implementation and enforcement mechanism of this law was so successful in colonial India that it has also been replicated in Bangladesh. And thus we see that any kind of a discussion as we are pursuing since last many lectures on common law remedies, its relevance, its scope, its application in the contemporary India. So the common law remedies for environment protection under the law of public nuisance in colonial India, in the context of two major enactments leading to Shore Nuisance Bombay and Colaba Act of 1853 and Bengal Smoke Nuisance Act of 1905, along with two more geographical spread of this law from in Bombay Smoke Nuisance Act 1912 and Gujarat Nuisance Act 1963. We are not going to discuss the salient features of the Bombay Smoke Nuisance Act and Gujarat Smoke Nuisance Act, simply because of the fact that the Bengal Smoke Nuisance Act 1905 was an skeleton law which have shaped the entire content and and the content and coverage of the Bombay Smoke Nuisance Act of 1912 and Gujarat Smoke Nuisance Act 1963, or in a broader sense we can say that the Bombay Smoke Nuisance Act and Gujarat Smoke Nuisance Act is said to be analogous law with minor modification in relation to the circumstances of the Bombay Presidency and Gujarat port towns and the shore towns and the industrial towns, but the basic essence of these two enactments passed in 1912 and 1963 is something have a lot of bearing on the umbrella law of the law of public nuisance in relation to a smoke nuisance, that is known as Bengal Smoke Nuisance Act 1905. So our discussion on common law remedies for environment protection under the public nuisance law in colonial India, encompassing shore nuisance, Bombay and Colaba Act of 1853, Bengal Smoke Nuisance Act of 1905, Bombay Smoke Nuisance Act 1912, and Gujarat Smoke Nuisance Act of 1963 is a very good discussion to see that how the air pollution control have been developed in the colonial India. Can this law be a guiding factor in shaping our independent India's laws relating to shore nuisance or the air pollution, or having a canvas of the harbor, the sea, the offshore, and the small and medium scale industries, and all kinds of the chimneys and furnaces and the fireworks which are being carried under the industrial establishment, dealing with a lot of activities like tower, digester, distillation plant, combustible fuel, and covering a broad range of mechanical, electrical, and chemical processes, and having smokes, fumes, vapors, soot, gases, how these things, these kind of environmental pollution can be controlled even in the modern India, taking recourse to Bengal Smoke Nuisance Act and Bombay Smoke Nuisance Act and Gujarat Smoke Nuisance Act, along with the Shores Nuisance Act, Bombay and Colaba Act of 1853. This serves a very basic background for common law remedies for environment protection under the public nuisance law in colonial India. And with this, I hope that this historical understanding of the public nuisance law or the legal history of the public nuisance law will aid to our learning of the colonial character of the law and having some kind of a broad guidelines and guidance even in the independent India and the contemporary India. With this, dear learner and viewer, I thank and I wish you a happy learning.